Assalamu alaikum, everyone, and welcome to the last call. We have with us today a true heavyweight in every sense of the word. He was the former senior puisne judge of the Supreme Court of Pakistan. He has been the Chief Justice of the Lahore High Court. He has been a maverick both as a judge and as a lawyer. He's been Pakistan's leading voice when it comes to climate justice. He's now taken on roles at Yale, at NYU, at LUMS, at DIAC, and he's doing great mediation work for some of the largest corporates in the world. We have with us today Justice Syed Mansoor Ali Shah, Justice retired Syed Mansoor Ali Shah. Thank you, sir, for being here with us today.
Thank you for having me. Thank you.
There's so much to ask you, there's so much to learn from you. So we've kind of split today's session into four parts. So I'll just give the audience a bit of an intro and then dig deep into the questions. So we're going to split the conversation into four elements. The first being the making of a climate judge, the first to my mind in this country. Moving on to climate justice as a constitutionally important topic, then the global south, and lastly, what is the road ahead that we see? So without further ado, my first question is going to come from, your days as a lawyer before the bench, pretty much. I think you kind of emerged from a Pakistani civil society where, environmental protection was largely driven by public interest litigation. The civil society was strong, it still is, but, sometimes we feel that it was more so in the last few years. So looking back, how do you feel that citizen activism reshaped environmental governance? And what did it really teach you about the power and the limits of the law?
Thank you. Thank you once again, Mikhail. The early years, you see, becoming a lawyer, it's all about, rights and justice. So at the very early stages of our legal practice, as a firm also, but and some of my partners also got involved into public interest litigation. We were very active with the civil society at the time also. Environmental matters can only be agitated properly, and perhaps many other matters also. They have to come from the civil society, because it's the civil society that actually faces the brunt of all these things. So environment impacts would affect the civil society first, certainly. So civil society has to react, it has to be active, it has to be vigilant, it has to come out on the streets and agitate the matter. So that was the time when few things were happening on the environmental front, and the civil society came forward, raising issues. And one of the articulations and one of the ways civil society could resist and articulate its resistance is through public interest litigation. And so while we were a corporate law firm and were doing other work, but had a great interest in teaching as well as in public interest litigation. So we took up some matters and took them to the High Court at the time and got a lot of relief, helped the environmental movement at that time. And I think the public interest litigation of the time added to the environmental movement in the country. This is, we're talking about, you see, early 90s. As we go along, we start off and get into environmental litigation. So number of cases made a difference. For example, the Dungi ground that you see today in Lahore is a result of the public interest litigation. So that's one. And then, there are a number of other things that we did at the time. There was a lot of work relating to environment, protecting the parks, protecting trees of the city at that time, yes. So I think civil society does play a very effective role in actually getting the movement started. And as I said, one of the ways civil society articulates this resistance is through public interest litigation, where lawyers like myself and others come in who would take up these matters and give a constitutional framework to this agitation through approaching the constitutional courts. Yeah.
I think what you've talked about is really important to kind of focus on a little more, because I think on the judicial side, the public interest litigation is the strongest thing that the civil society can act on. But I think there's a very strong element of educating the judges even. I think environmental PILs really helped shift how courts viewed public harm, what in their mind was harm truly. So with that in mind, do you think there are like specific moments or cases, for example, the Dungi ground that you've just mentioned, that really marked a turning point in Pakistan's environmental jurisprudence going forward?
Yes, I think at that time, I remember the first case was relating to the air pollution, much before the Dungi ground thing came up. And we were all very upset with the vehicular air pollution. And I'm talking about 1996. And that's the time when the city was, we still have the air pollution problem, but at that time it was also there. And we thought that we need to do something about it. So at that time, I was teaching at LUMS, and all my students at the LUMS became my law students became the petitioners, and we filed a petition at the High Court way back in '96. And when the case went up to the judge, that was perhaps one of the first environmental cases at the Constitutional Court. So when it went to the court, the judge at that time did not really give it much weightage. And they thought, well, it's okay, we'll look into this case later. It looked like a bit of a fancy litigation to the court. But 10 years down the line, when the case was decided, I think the awareness had really come full circle and people understood what was happening. And the court came up with a very robust judgment. It's a reported judgment under my name, and came out as a very strong judgment where the result of which was that we got rid of the two-stroke rickshaws in Lahore. That was a major case. And now, as you see, we moved on to CNG rickshaws, and now it's a four-stroke rickshaws that you have in the city. So I think one of the immediate results of that litigation was getting rid of the two-stroke engine rickshaws, because they were creating huge smoke and air pollution at the time. So that was one, and that was like, students getting together and bringing that matter to the court. It was all, nobody was charging anybody for anybody, but it was just doing things for the society, for the uplifting and protection of the environment, for that matter. Then came the Dungi ground case, and as you might recall, that was the time when they were trying to set up an IMAX cinema in the Dungi ground. Now, Dungi ground is a big ground in Gulberg, which acts as like lungs of the city, where number of young people, kids and children from the neighboring neighborhoods, which are not that privileged, come to the park, use it for cricket or football, for other enjoyment. And so that's like a playground right in the heart of the city. It is also green, it also has trees, it also acts as lungs of the city. And it was there in the master plan, and they decided just with a stroke of pen that let's just build a plaza here and an IMAX cinema. And that was something that we went against. And at that time, the powers to be, or the government in power, wanted that IMAX cinema. So it was a very difficult PIL, because the whole force of the government was behind that project. But we stopped it, and the Supreme Court granted us at that time an interim relief. Later on, I became a judge, but then finally the High Court decided the matter in favor of the ground. And today, if you pass by on MM Alam Road, you see the Dungi ground there, you see, and it is there because of this litigation, because of this active involvement of the civil society. And number of people were petitioners at that time. I still remember Cecil Chaudhary was a petitioner, Ardashir Kavusji was a petitioner, and a number of other stalwarts were there. And when the pressure came, they resisted it, because there were pressure telling them to withdraw this petition, but they did not budge. So that's the kind of strength of a civil society that's required to lead to better governance in the country, and that is the kind of civil society required to make a difference, you see.
Shah Saab, I think, a judgment that you've authored that has done the rounds in Pakistan and, the globe has been the Asghar Leghari case, Leghari versus the Federation of Pakistan, where you historically reframed climate change as a fundamental rights issue, arguably ahead of its time. Can you kind of guide us through what constitutional philosophy really guided you in making that shift?
Yeah, thank you very much. So you see, I need to go a little back and understand and make everybody understand that there was environmental litigation was going on. We were quite deeply entrenched in environmental litigation, and as a judge, when I was elevated in 2009, we were looking at environmental matters and international principles like precautionary principle, the public trust doctrine, the intergenerational, the intragenerational equity, sustainable development. All these principles, international principles of environmental law, were all there, which we were using to deal with environmental issues. The only difference was that the polluter was in the country, and we had the jurisdiction over that polluter, so we would pass directions shutting down a factory, shutting down any event that was happening that was causing environmental harm. But then, while we went into this and there was a rich jurisprudence that was there, we were giving a constitutional voice to this environmental protection. In comes climate change, and the dynamics changed because the major change was that the polluter wasn't in the country. I mean, there was no polluter. I mean, this was happening somewhere in the West, and after effects of that were reaching Pakistan, and we were not even contributing to the greenhouse gases, but we were suffering at the hands of it. So we had to look at this problem differently. But we were quite there because of the environmental jurisprudence that we had worked on for almost a decade. So the principles that we'd evolved were all there. We had the tools, but we had to deal with climate now, which is a totally different dimension. So Asghar Leghari is a case, that's the first case that comes in, where a farmer slash lawyer who wanted to raise a question before the court that he has agricultural land and climate change is going to totally deprive him of his livelihood. Because of the global warming, he might just lose out on this agriculture that he has. And there is a government policy called the National Climate Change Policy of 2012, which is lying on the shelf and nothing is happening. And something has to be done because we need to start looking at new plants, the way we need to irrigate lands, and all those things that were given in the policy need to be given effect for any farmer to survive. So we took up the matter and we actually made sure that the policy is implemented. And the policy was very well designed by the government, by the way. It had short-term, long-term, and medium-term goals. And we got that going. But we understood when we sort of called the government to court, we realized that the capacity isn't really there. People are not really understanding what climate change really is. They had a rough understanding of what global warming was, but they did not have a deeper understanding on how to address this issue. And we thought the best innovation at the moment would be to come up with a commission. So we called it the Climate Change Commission, which the court has empowered under the General Civil Procedure Code to form. And in that commission, we invited IUCN and WWF and the other international NGOs, along with local experts, along with lawyers, along with the government officials, and the petitioners to sit down together, look at the policy and see how they can go and implement it. And I think that international resource and local resource, which had expertise in environment and climate, helped build the capacity of the government, and they all worked together. And that was not an adversarial litigation. It was very participatory in nature. And they all came together. And by the time, I left the High Court and the case came to an end, about 60% of the goals that were there in the policy had been achieved. And I think the government got the drift of it and they got moving on it. Of course, the courts can't run governments. They just do a bit of a jump start and things start happening. So I think it's a major case in introducing climate change, giving constitutional voice to climate change, bringing in the entire framework of fundamental rights on which hinges the entire concept of climate justice in Pakistan. So we introduced the concept of climate justice. We also introduced the concept of water justice, which is so critical for Pakistan being a water scarce country. And this was all coming out of that claim that had come to the court that a farmer is simply saying, please look into my livelihood. How am I going to deal with life? And we picked up the policy, issued a mandamus, as it's called. We pushed the government to follow its own policy. We did not create any policy. We did not invent anything. We just said, let's follow the policy, but gave it a constitutional voice supported by fundamental rights. And so that made it a very robust kind of a framework for the government to lead and also for future generations to follow and use it for other climate litigation that came. So climate justice got coined in Asghar Leghari for the first time. Water justice got coined for the first time. But more important than the coinage itself, the fact that fundamental rights were directly connected with climate justice, and climate justice was realized to be something at the heart of fundamental rights. That's what's important about Asghar Leghari.
I think climate justice is a concept that I've seen as a phrase being used globally very, very widely now. And I think credit to you and some of your fellow judges for actually taking the baton, especially at these international forums. But I think just kind of I want you to roll back the decade and kind of give us a summary of how do you actually reflect on the work that was done during the Asghar Leghari case? Of course, the commission was a very innovative idea and it offers a bunch of lessons. But do you feel that what you did at the time and the action that followed, did it transform governance? Or do you feel that there are now clear and obvious limitations to what judicial intervention can actually achieve, given that you're also very cognizant of the fact that you don't want to have judicial activism go into the mandate of the government? It's a very complex policy domain, right? So how do you unpack all of this in the last decade's experience?
I think post Asghar Leghari, I think we set the pathway. Climate justice was introduced and had a direct intersection with the fundamental rights, and a lot of other cases came after that. I mean, if you look at a series of cases from the Supreme Court as well as the High Court, followed climate justice and have been reiterating the concept of climate justice. For example, the DG Cement case, where cement plant was being expanded in Talakahar area, was stopped that they can't. And the court said that has a direct bearing on climate justice because it's a water scarce area and you're going to destroy the villages around because cement plants are water guzzlers. So that also highlighted climate. Then urban planning, we brought in climate change into it, that all sorts of urban planning in the city by the authorities that look into capital development or provincial development must keep in mind climate resilience, and they need to ensure that the buildings are climate resilient. So that got introduced into urban planning. So it just went on, and recently, if we see a case where we even touched upon climate finance, so climate justice moved on to climate finance, and interesting developments on the jurisprudential plane. But that does have an effect on the government also. They start making policy. Climate Change Act came about, and I think that came about because of this jurisprudence that was all there in the background. It does help. Nobody takes credit for it. We don't want to take credit, neither does the government give us credit. But I think, silently these things pass on to each other and the institutions learn from each other silently. And I think it did go into the policy domain and it did make a difference. There was the entire ministry came about of climate change. They've been doing their work, what might be the nature of their work, but they're doing good things about it. So that's how things interact with each other and institutions learn from each other. I think there's a lot of work that that governance requires and the executive needs to do. But still, I would give them credit that they did follow Asghar Leghari because nobody came back to us again after that. And I think the policies did go through, and they need to continue. It's not a one-day job. This has to keep going, and so that's how the institutions silently help each other without giving credit to each other.
I think my question here is going to be how you've actually fundamentally at times highlighted that you feel that climate jurisprudence in the global south is fundamentally different. So what do you think is the distinguishing factor? Is it our vulnerability? Is it the fact that it's a necessity for us? Or do you think that, we just have judicial mavericks sitting here who are being very creative with the judgments coming along? Or is it just a mix of everything? I'd love your take on this.
Yeah, so I want to clarify the distinction between how climate change or climate justice is perceived in the West and how we look at it in the South, global South, or global North and global South. So global North is an issue relating to mitigation because that's what their problem is, and they try to mitigate. So most of their jurisprudence simply says reduce the emissions. And that's a clear direction that you have to maintain within the limits as agreed in the Paris Agreement. Also, we need to make sure that the temperature doesn't rise above that limit. But if you look at the global South, mitigation is not our problem. It is adaptation. And adaptation is much bigger a canvas than mitigation. Mitigation is just emissions need to be controlled. Whereas if you look at adaptation, it's a multi-sectoral issue. I mean, it deals with agriculture, it deals with irrigation, it deals with urban development, it deals with forestry, it deals with all sorts of health, it deals with forests, it deals with number of sectors, you see, with energy, and so it's energy security, health security, everything comes in. So if a case were to come to us, for example, relating to, as I said, about a cement plant that is developing a project somewhere in a water scarce area. Now, this could be a simple issue that, no, this water scarce and it's a fragile area, we can't allow you. But then it is a direct case of adaptation. I mean, why is a water scarce area being put under stress? And that cannot be allowed in in a country which has to be climate resilient. So climate change equation or dimension comes into it. So it's very important to understand that for us, the judges writing about climate justice in the global south have to be far more creative. They have a bigger canvas at hand. They have to attend to urban development because that carries climate resilience in it. They have to look at irrigation and agriculture because climate dimension comes into that also. So it's a very broad based dimension that we have to look at, and the matter might not come to us, which clearly tells us that it's a climate issue, but we sense that out of it because we think that all these sectors require climate resilience. So number of cases that have come to us did not even mention the word climate change, but we thought because of the adaptation issue, every sector has to adapt to the climate justice requirement, which is not the case in the West. So I think the jurisprudence coming out of the global south is far more creative and innovative and far broad than the jurisprudence in the north.
I think in this context, right, climate change for Pakistan is not just an environmental issue. It's a fundamental development challenge. It's a survival issue for us at this point in time. We've seen, for example, the floods, the droughts, the glove melting, a number of things coming to life. So, and I think that, the adaptation buzzword that is so important that, sometimes we lose track of. I don't think the adaptation can possibly work without climate finance. And I've seen you speak about it. I've seen you talk about climate finance and climate justice going hand in hand. So do you feel in that context that climate finance is just a policy tool, or do you think that it can be constitutionally linked to fundamental right?
Yeah, so that's a very interesting question. While we were, churning out judgments directing the government to address climate change by, issuing directions that this has to be done or that has to be done, and we realized that even though we come up with very interesting jurisprudence and directions, they hardly get followed. And because the reason for that is because there is no money. The state can't fund those changes that we direct them to do. And it took us some while to understand, and I'm talking about myself, it took me some while to understand that, wait a minute, I mean, this is not, nothing is really happening on the ground. And that's because it requires huge funding. I think adaptation is perhaps the most expensive thing to do. So how are we going to do it? Where is the money for it? So then we started examining and looking at the global funds, the green funds of the world that they promise us at the COPs. And we realized that nothing really trickles down. The procedures are very cumbersome. And if you look at the latest agreement, loss and damage, even there, under that head also, a very meager amount gets translated and comes to Pakistan. The procedure is very difficult. I don't know who can apply, how can you apply, how do you process those applications? I think that's intentional to my understanding, that this money is not going to come to us. And we've seen that in the 222 floods, $30 billion was our ticket. And what did we get? I mean, maybe some meager amount which doesn't even get disclosed. Nobody knows about it. So I think as far as the global finance on climate is concerned, nothing is trickling down to our country. So that sort of brought us to the question that climate finance is so critical, and we need to come up with our own homegrown solutions for this. And that's why we, in a recent Vasa case, we said that climate finance is a fundamental right.
So with that in mind, what in your view is the single most urgent shift Pakistan must make today to shift its environmental crisis, confront its environmental crisis?
Well, firstly, let me compliment Breathe Pakistan by Dawn. I think that's a great awareness campaign, and I think that's making all this conversation happen. So that's wonderful. Largely, I think, you see, the civil society has to take charge. They have to get active. Nobody does things for you unless you get up and ask for it, claim it, agitate for it. So I think an active civil society makes the difference, and that helps shape governance in the country also. I would, of course, want the executive to look deeply into this most serious existential threat that Pakistan faces more than anything. And I think that's not the priority that's been given by the state of Pakistan to climate, and I think that must be given. It is a very serious threat to our survival, and it is a direct fundamental right issue more than anything else in the country, but the state perhaps doesn't perceive it that way. I think they need to do that. That's one. But the civil society can make that happen by approaching the courts, by filing petitions, by coming up with public interest litigation. I think there have to be a larger cadre of lawyers who need to push the courts in this direction, because it is a very serious threat.
Fair enough. And I do agree with you. I think nothing comes in life for free, and the Pakistani civil society has had a very strong track record of taking what it feels is right. And I think with that, I also want to link up to the fact that you're an inspiration to many, especially in the legal fraternity, the young lawyers, the upcoming judges, but also across the larger canvas. And we have a lot of these young people who are going to be at the Breathe conference in Islamabad in 2 weeks. So, what advice would you really give to this younger lot who are energized, who want to engage with climate justice as a concept in a meaningful way, give back to Pakistan? What would be your parting words to them?
Yeah, so I would really tell all the young lawyers to remember that law as a profession is not about making money. It's about fighting for justice, making sure you pull up people, help people, and provide justice to the voices and to the people who can't really come to the court. So you are the voice of the voiceless, and that is the major role that you ought to play, be a voice to the voiceless. And that could be through public interest litigation, bringing claims, fighting for things that the society requires, for the uplifting of the society. So while you work on corporate matters, go ahead, make money, do whatever you want to do, but make sure you are addressing social causes, because that gives voice to people who can't come to court. And that is one of our duties as lawyers, to help uplift the society. And I think as far as the environment is concerned, we need far more public interest litigation petitions coming to court on climate issues, on environmental issues. And I think this exercise must continue. We need to keep on filing claims, keep on agitating. If you see around the globe, that keeps on happening. All the young activists are filing cases before the courts of the world. And I think we must do that too. That pushes the government in the right direction. It actually helps the government decide, come up with new jurisprudence, new rights are developed. And I think that's the cause that the young lawyers must keep in mind. It's not about staying in the chambers, making money, but it's going out and helping people out so that you can provide justice to people who can't actually access justice themselves. Thank you.
Thank you, Justice Shah. This has been an extremely enriching conversation. Lots to think about on a number of fronts. If you're a young lawyer, a judge, a member of the civil society, or in any other profession for that matter, there's impact to be made across sectors. You just need to get your voice up and try to be on the roads like he was when he was a young man. We've talked about the global south. We've talked about our collective responsibilities in the road ahead. We've talked about climate justice as a concept, and climate finance now coming up as a fundamental right as well, for the days that lie ahead for Pakistan, where we talk about development challenges as well as a core survival issue that is coming up ahead. So with that, I'm so grateful to you, Justice Shah, for taking some time out to be with us here today. And I hope this episode was as enriching to the audience as it was for me as a learning experience. Thank you all. Hope to see you next week.